today is trial day 8. The question that looms large is, will she or won't she? Donna Adelson going to testify? She going to testify today? How many more witnesses can the defense possibly have? Because I don't know what they're doing, but it sure seems like they were kind of stalling for time yesterday. Maybe it was just me. Donna had her friends testify yesterday. She had a tech expert testify yesterday who said basically, oh yeah, well, the state didn't deduplicate things, so their numbers are a little higher. But other than that, everything I agree with. How many more witnesses can they possibly have?
And at minimum, Ms. Cappleman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
Not another witness sitting in the courtroom. We ended court yesterday with the judge saying no more violating the rule of sequestration. However, the judge said we need to take a look at the sidebars to see if we discussed this witness being able to be in the courtroom. So there seems to be some disagreement about whether this was previously discussed or not because of what the judge said.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Judge,
All right, defense.
on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
as to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your.
The court said very clearly, this conversation was about adverse experts, the experts from the other party. Defense experts can review the testimony of prosecution experts and vice versa. These are same.
Case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Yeah, that's on the defense.
Judge.
Why should this witness be permitted to testify?
They shouldn't. Yeet.
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
And I would like to have a pony. However, I don't.
We were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Miss Bailey to be present during Kristen Adamson's testimony.
Oh, you were wrong.
And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week.
You should have brought it up again this morning and just said, so we are clear. The judge could keep this witness out.
Ms. Cappleman, what are you asking for?
Exclusion!
I'm seeking exclusion, Your Honor.
Exclusion!
To exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little...
Wait, is that the witness standing in the back of the court? Because when they called the next witness, was that the woman that was walking forward? Is she still standing in the court?
myth that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But you did admonish the defense to not let it happen again, and now it's happened again. So, you know, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Cappleman, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Exclusion is an extreme remedy, and if Donna Adelson is convicted, and this is a strong case against Donna Adelson from what we've seen, in my opinion is not shifted on that. If Donna gets convicted, excluding this witness creates a potentially large appellate issue depending on what this witness is. So while the court could exclude this witness, I don't know if they will, because the court's like, you know what? If we're going to rule against somebody in this situation, we're going to rule against the state. Why? You can't appeal. She's acquitted. You can't appeal. She's convicted. She appeals. When you have to balance an extreme remedy, it's real unusual to take it against the defense. However, this is a circumstance where it could happen.
Judge, if I may.
The court's not happy at all.
Viewing Earhart, exclusion of the witness, court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what
You gonna
would
do a
have
voir
been
dire?
had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
Why?
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness.
Miss Bailey's standing in court. Did you hear the court? Miss Bailey, come to the witness stand. Okay. We're going to voir dire this.
In preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your preparations?
I think so.
Okay. No, Your Honor.
Please step down, Ms. Bailey.
But you were standing here the entire time. So I imagine the court's going to say, you know what? She read the prior testimony. The prior testimony is consistent, and give the jury an instruction. That would be my guess. Well, this morning we ended up at code red because the defense, if we're being generous, misunderstood the court's ruling regarding sequestration of witnesses, though the court said, literally, it's here in black and white. I said no. And the defense is like, but we asked. And the court said, but no. There was discussion regarding the sequestration order, which means witnesses cannot watch the testimony of other witnesses, whether in the courtroom or on YouTube or whatever. The exception to that was for opposing experts. So a tech expert from the defense could watch a tech expert from the prosecution and vice versa. The defense had their expert, who was coming up to talk about divorce litigation, watch the testimony of Wendy's divorce attorney. They had asked for that. The prosecution did not agree to that. The court did not grant that. It was done anyway. So the court is now having to decide whether that witness gets excluded and whether or not their testimony would be essentially tainted by listening to the other witness. Would they try to comport their testimony to that other witness's testimony? So the court has the option to yeet the witness and say they can't testify at all, or say, yes, they can testify, I can give an instruction to the jury, or say, yes, they can testify, you can cross-examine them on it, go get them. Exclusion is an extreme remedy. And with an expert who has already read the testimony, I don't know if the court is going to grant that remedy. My question will be if the court will admonish the jury about that violation. But the court said at the end of the day yesterday to the defense, make sure there aren't any more violations of the sequestration order. And where did we end up today? Another violation of the sequestration order. The court's frustrated because the court's instructions aren't being followed. And what should an attorney have done in that case? If you are unclear with the court, ask them. Your Honor, I just want to be clear. Your ruling last week, it was a 3-day weekend. Just to make sure, you said at the end of the day yesterday, no more violations of the sequestration order. Just so I'm clear, this witness can sit in. We good? Because it would have cleared everything up. When you ask for forgiveness, not permission, we end up in this situation. The remedy that the prosecution is asking for is exclusion. It's a severe remedy, especially against the defense. And if down the road, Donna is convicted, this becomes a large issue for appeal if this witness is yeeted.
Court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected.
I don't think it will be.
By the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this
he's going to deny it.
This being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter.
If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
Well, I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be.
Ma'am.
But in this case, they weren't.
They weren't? How do you know?
Get her!
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached
No, she won't agree with you.
issue, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
Yes.
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is
This witness trying to play coy with the prosecutor is just not going to work.
Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with
Perhaps.
that. You can't agree with it. Strike the question.
Let's try to summarize what happened today. The defense called two incredibly duplicative witnesses to talk about the divorce case. It seems that the defense's point is that, per the divorce attorneys, this was not a highly contentious divorce. It did not have hundreds of thousands of pages of filings. It did not have binders and binders and stacks and boxes of binders. It was not highly contentious. It was a normal divorce case. And the divorce itself to the divorce agreement took 10 months, which is quick in a divorce case with children. It took about 10 months. And then the filings started to ramp up after that. The prosecution is saying that this was a contentious divorce based on the conversations and emails between Donna and Charlie and Wendy and the wiretaps and the text messages. Some based on the filings, yes, but a lot based on the behavior of the parties. So the defense witnesses came in today to say, well, as lawyers, this is not contentious. We've seen worse. Sometimes as attorneys, it is hard to remind yourself that just because you've seen worse does not mean that the people in front of you have. And this is the worst for them. Do Donna's emails to Wendy indicate that this is the worst thing happening in her life? Donna's emails were saying, you have to explain to your lawyer that this is critical. You have to tell your lawyer how important this is. You have to tell your lawyer that this is a non-negotiable. So no matter what Wendy might have been buffering between her mother and her lawyer, what Donna thought is what matters. And how Donna was reacting is what matters. And the court reminded the defense attorneys after a hearing about one of the witnesses that was supposed to not be in the courtroom that was in the courtroom, and then ended up testifying after the judge found a second violation of the sequestration order. I think the defense did more damage to themselves with that witness than they helped, because the witness basically just said, yeah, what the last witness said. Oh, well, as Kristen said. Oh, well, when I talked to Kristen, she said this. They called an expert witness to testify about what the witness before them testified about, the witness before them being the actual divorce attorney who filed the motions and was in the rooms. I don't know why they made that choice for the duplicative testimony, unless it was just to see like, hey, we've got witnesses. But I'm sure the jury's just sitting there going, are we going to hear what the defendant thought or no? I'm sitting there wondering that. It is just a interesting choice. And it's striking to me that when we get to lunch today, the defense, through Jackie Fulford, her questioning, her opening statement, and her long questioning of some of the witnesses have been about what a great human the victim in this case, Dan Markel, was. And then counsel gets up during this witness and talks about, you know, if the nickname that Donna Adelson and her daughter were calling Dan Markel was justified, and whether his legal motions were sufficient, whether the things he was asking for were warranted. And it's such a stark contrast between the rest of the defense's case. The rest of the defense's case has been, this was a horrible murder that took a wonderful parent away from their children. And then we get to these witnesses, and it was very telling that they were saying, no, he was asking for unreasonable things during the divorce. He was unreasonable with this. He was unreasonable about that. It was just a stark contrast to the rest of their strategy, which was confusing to me, versus sticking with the strategy of, this wasn't highly contentious. It was settled. There was really not much happening in this divorce, which I don't necessarily agree, but at least would have logicked in my brain. So the defense is supposed to be talking to Donna Adelson during lunch about whether or not she will testify. I don't know if she's going to change her mind, but the defense indicated all pre-trial that Donna was going to testify. But looking at how they're filling the days with the witnesses, I don't know how I feel about whether or not Donna's going to testify. My personal opinion, it will not help her to testify. Donna's vibes, she's going to want to explain it to everybody. And we're going to have to see where we land in between those two things.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Miss Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The
She
defendant
doesn't-
in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter.
So it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
Yeah.
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Cappleman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had.
No, that's not at all how it's been made to seem. Because the way that it seemed to me from the defense is that the day Donna's getting ready to go to the airport, they ring-a-ding-ding the prosecutor and are like, hey, there a warrant out for our girl? No. Can she travel? Yeah. Any travel restrictions? No. You'll let her turn herself in, right? This happened before Charlie was convicted because y'all made it seem like it happened the day she was going to the airport.
At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these 2 rights?
You have to answer the court.
This time I don't want to testify.
Very well.
Whoop, there it
As I
is.
previously stated, the jurors will be instructed that your silence
Your
cannot
bluff
be
got
held
called.
against you in any way.
The defense, after quite a lot of fuss, has rested. The prosecution is not bringing in any rebuttal, though they admitted a stipulation to show that Patricia Bird, the jailhouse informant, was never on any of the defense witness list. It was a point that was contended, but instead of bringing a witness, it's a fact that can be agreed upon because it either was or wasn't. And I'm sure the prosecution went to the defense and said, here were all the witness lists. Can you show me where it says that name? No? Okay, then we're done here. The defense has 2 rulings with regard to Donna Adelson's planners and whether or not additional information from the planners will come in as the rule of completeness. He said, we're not offering them for the truth of the matter asserted, and continued to argue that they would show that Donna was planning to sell items since January of 2023, not just after Charlie's conviction. And so that those had been planned all along. She wasn't selling them because she was leaving, but that seems to me to be offered for the fact that she was going to sell them in January, which is what they're trying to assert. So they're arguing rule of completeness. I don't know if the court is going to admit it. As to the 2023 planner, the entire planner has been marked and foundation has been laid because that planner was seized pursuant to the search of Donna Adelson's residence. So that entire planner was marked. Only certain pages were admitted into evidence. The defense is asking to admit more of it for completeness. The prosecution is objecting. The court is reserve ruling. Now, as to the 2014 planner, the prosecution omitted 1 page that had Dan Markel's car, make, model, and license plate number on that page with some other information like Wendy's car, no license plate, etc. The rest of the 2014 planner has not been marked into evidence, has not been marked for identification, and no one has laid foundation for it. So I don't see how they get around the fact that there's no foundation for the 2014 planner. There aren't any more witnesses to call. No witnesses laid the foundation for it. There is foundation for the 2023 planner. The hearsay issue is separate. But as to 2014, there's no foundation for it. So I don't think there's any way that that can come in. But the court's going to reserve ruling on that. And now we are going to the charging conference, which is going through all of the jury instructions. I'm very interested to hear the jury instructions with regard to these charges: murder in the first degree, conspiracy to commit murder, and solicitation of murder. So the instructions as to the crime. And then remember, we still have a special jury instruction hanging out there with regard to the witness who sat in for the other witness's testimony. That was still part of today. 8 days of trial, 27 witnesses for the prosecution and 11 witnesses for the defense. The prosecution is rested. The defense is rested. The prosecution will not be bringing a rebuttal case, and closing arguments will be tomorrow morning. The defense and prosecution did the charging conference with the court, going through the jury instructions, the lesser includeds that will be added to count 1, and the rest of it. Both sides have said that they would like 2 hours for closing. We will have prosecution, defense, prosecution rebuttal, like we saw in the Sarah Boone case and others. So tomorrow we've got about 4 hours of closing arguments, plus, relative breaks. And I would imagine the court is going to want to get all the closing done, send the jury back for lunch, and then let them begin deliberating. So will they have a verdict tomorrow? That's going to become the new question. Today's question was, does Donna Adelson testify? And that came to a resounding no. I have to wonder if this morning Donna thought she might testify, saw George's cross-examination, and went, yeah, no, I don't want to do that. That does not look enjoyable. Or Was Donna never going to testify? Or did her defense attorneys remind her, look, there is not much that you can say that is going to help, but there's a lot you can say that is going to hurt. We might never know the answer to that, but we did see Donna pushing on the judge for more time. And many of you asked in the chat, is Donna saying, but I needed more time, Your Honor, going to be a basis for appeal? Well, if Donna Adelson is convicted by this jury, then yes, of course she'll bring it up on appeal. Is it going to go anywhere? Yeah, probably not. The court has given the defense a substantial amount of time in this case. This case has been continued numerous times. So the fact that the defense just said, well, we want to talk to her more, is not going to be sufficient. The defense didn't say, Your Honor, this thing came out of nowhere in this trial, and so we need more time. Plus, trial yesterday ended early to give defense in part more time to talk to their client. So no, though it might be raised, it's not going to go anywhere. She knew that she would have to make this decision, and she has decided to testify in other hearings. Also, she's seen these witnesses testify against Charlie Adelson. She has had the report. She has had the attorneys. She knows the evidence against her. There aren't surprises. So her not having adequate time to talk to her attorneys is on her and her attorneys. Also, before Charlie Adelson even got sentenced, she was texting Wendy saying, I know I'm next. So she's been preparing for this for quite a while. She had a criminal attorney back in 2022, seemingly around the time that Charlie Adelson got arrested. If you go all the way back to the wiretap calls that most of us have tried to purge from our working memory, when the bump operation went down in 2016, what did Donna do? Well, Donna called Charlie Adelson up and said, I was hand-delivered a thing. And Charlie was like, oh my God, it's the IRS. And Donna's like, it's not the IRS. God damn it, Charlie, it's not the IRS. That was hyperbole on my part. It's about the two of us. So you probably know what it's about. So Donna has known what this is about since at least 2016. If you look at all the behavior in 2014, she knew what it was about then too. Her defense attorneys saying that they needed more time and they didn't have enough time. They have consistently said that, but the courts, when they look at this, are not going to look at these defense attorneys given the amount of time and the continuations that they've had and say you truly did not have enough time. That is not the case here. I think the prosecution has put forward a strong case. The defense arguments are going to be, Donna didn't know. Donna would never. Donna didn't think it would go this far. Perhaps they will argue that, but there's no evidence that Donna spoke to Katie McBanawa or Sigfredo Garcia. There's nothing connecting Donna to them. However, the evidence of flight goes to consciousness of guilt. The script, if the jury believes that Donna wrote the script and gave it to the jailhouse informants, even if they don't super believe the jailhouse informants, even if the jury is sitting there going, well, would people kind of lie to get what's best for them? Sure. So I don't know if I believe all of what they said. The script, though, and is the jury really going to believe that the women in custody told Donna what to write in the script? I just find that really difficult to believe. But we'll see what this jury does. And again, the instructions are going to take them some time to go over because we are looking at the first-degree murder with lesser included crimes, the conspiracy to commit murder, which is the agreement and the acts in furtherance thereof, and then the solicitation. Was someone hired to do this? So was someone hired, or did they just randomly decide that they were going to go do it and then try to ask Charlie Adelson for money down the road? I think Donna saying, I know I'm next, but I'll take care of it, and then that open phone call where the jury got to hear Donna in her own words talking about what her options were after Charlie was convicted. I just wonder how persuasive Donna's own words will be to the jury at the end of the day. She's talking about settling her estate. She's talking about a one-way ticket. She's talking about non-extradition. And she's talking about, can I get out in time? The jury's going to get to decide. They have 3 counts to decide. The sentence for all 3 counts is going to be the same. What I'm interested to see is how the prosecution uses their train car analogy with all of this. If the defense continues to lean into the victim was an amazing guy like they did in opening, because after today's testimony, I think it's going to feel real weird. I mean, today's testimony, some of it was really strange in light of all of the defense testimony. I think the defense's best witness today was the criminal defense attorney at the end, who said, no, we were talking to Donna. She said she was going on vacation. She had been told that there wasn't a warrant for her. She had no travel restrictions. She told us she was distraught and she needed, a vacay for her mental health. I think if they had just brought in that witness yesterday, I don't think they needed all the witnesses about the divorce today. Even if they wanted to bring in Wendy's divorce attorney, I think the expert witness was really off-putting. And I wonder if the jury thought that too. It was so cumulative and it was just wild testimony, but it gave the prosecution the opportunity for a fiery cross-examination. And I think the jury was probably like, damn, Georgia. But the prosecution made an excellent point in that cross-examination. Just because this divorce case might not have been a big deal to you doesn't mean it's not a big deal to the parties going through it. Because to litigants going through a case, it is the biggest deal going on to them. And that's exactly what Donna's emails said. Donna's emails show that she thinks it was a very big deal. And I bet they're going to highlight a whole bunch of that in closing tomorrow. So what does the defense highlight? Donna wasn't fleeing the country for consciousness of guilt. She was taking a vacation. Donna was stressed after Charlie got convicted of the exact same things she's being charged with. Donna and Charlie were talking about dentistry, that Donna didn't know, that she was shocked. And her friends that were on the phone with her said she was shocked when Dan Markel was shot and that she didn't expect for this to happen. When the jury is reminded by the prosecution, as they will be, of Catherine McBanawaz's testimony, the musty money text messages, the dropping the money off, and all of the emails, I'm curious to see what this jury will do. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.